come to the stage to sit in to start the law seminar. I'm requesting the Mr. Purushothaman, Mr. Meenakshi Sundaram, Rajakumari, Chandrika Subramaniam, Saravanan and Wilson. Yes. வாங்க ராஜகுமாரி. வணக்கம். நம்முடைய 8வது உலக தமிழ் பொருளாதார மாநாடு மற்றும் சென்னை உலக பொருளாதார உச்சி மாநாடு வெற்றிகரமாக 2வது நாள் நிகழ்ச்சி நடந்து கொண்டிருக்கிறது. நேற்று மாலை நிகழ்ச்சி தொடக்க விழா மிக சிறப்பாக நடைபெற்றது. இன்று காலையிலும் அரை நாள் நிகழ்ச்சி மிக சிறப்பாக நடைபெற்றது. இப்பொழுது நாம் மதிய உணவுக்கு பிறகு நாம் கூடியிருக்கிறோம். இந்த நிகழ்விலே சட்டமும் பொருளாதார வளர்ச்சியும் வணிகமும் என்பதை பற்றியான அமர்வாகும். குறிப்பாக வணிகம், தொழில், எந்த ஒரு கிருஷ்ணகுமார் அவர்களே இடத்துல உட்காருங்க, சீட்டில் உட்காருங்க, எல்லாரும் இடத்துல உட்காருங்க. எந்த ஒரு நிகழ்ச்சியா எந்த ஒரு செயலாக இருந்தாலும் சட்டம் தன் பணியை செய்யும். வித்தவுட் லா, வித்தவுட் you cannot do anything. You want to marry someone, you have to get a legal certificate to go to foreign country. If you want to go to foreign country, you need a passport. If you want to join for something, you want a birth certificate. Like that, anything and everything to go according to law. Law is playing a very major role to start a company, to do business, to start industries, for anything and everything. That is why we always include law as one session in this economic conference. In this session, we invited Honorable Justice T.N. Vallinayagam, former judge of the Karnataka High Court, and also he practiced in Chennai, Madras High Court, as well as in many other Supreme Court and many other places. Now, after retirement, is fully engaged on legal, social, and economic developmental activities throughout Tamil Nadu. He is a patron for many organizations. He is always with us. He is one of the patrons for our own activities. The economic conference, whenever we organize, all meetings he used to come, and also we used to invite. Without him, we never do anything. Like that is our part of our activities. Now I'm requesting the session people to stick on your time as per 10 minutes for everyone. Then only we can finish up that. First, I want to invite actually the chair. Before chair, I am requesting Chandrika Subramaniam line la irukangala paara. Chandrika Subramaniam is a attorney, is a principal solicitor, barrister, practicing in the Supreme Court of New South Wales in Australia. Actually, she was studied in India, Chennai, Madras University, and she worked here. She was a journalist, she was a lawyer, she moved there. She is now very well established in Sydney, and also we are waiting for our air ticket to invite me to give a speech in Sydney, but that is why we are unable to come because of the COVID. Otherwise, we would have visited 2 to 3 times under our hospitality. Anyway, I am very happy to welcome her. Tomorrow also she is receiving an award from us. I am very happy to welcome Chandrika Subramaniam. Your services in the legal field, the Tamil field, social service, women development, all wonderful. Welcome. You present your speech for 10 minutes only. Very, very strict on this time. Thank you.
Thank you very much, everyone. Good evening to everybody. Thanks to Madras Development Society inviting me to attend the 8th Global Economic Summit, World Tamils Economic Conference, Chennai 2021. I thank personally Dr. Sampath And I also welcome and salute to honorable judges, learned colleagues, dignitaries, members of the legal and economic professional. Law and economic development. Economic development is the demand of the constitution to achieve the economic goal of any country aiming to improve social welfare for every citizen of that country. Ideally, the development is sponsored by national financial sources of the country. However, the country may face limitations in fulfilling the Himalayan task, which extends invitation to investors, both domestic and foreign, to be part of national economic development. In order to regulate such investments, it is inevitable to improve the competence of the country itself. A country's legal policy should direct the law development authorities to support the realization of continuous economic growth, to regulate issues regarding economy, especially business and industry, and also to create certainty in investment. In particular, law enforcement and protection laws development needs implementation with constant renewal of law. This will be completed in the light of balancing the plurality of legal system and the influence of globalization. By doing so, the efforts to increase the legal certainty and protection of human rights will be given priority. This will also address the new challenges created by the constant changes in the legal and the economic environment. The role of law, which is very important in economic life, is regarding the ability to influence the certainty level between human society. The global economists believe that modern economy sees the expectations of individuals are the determinants of economic actions, and because of that, they are crucial in deciding the equilibrium of economy and the stability of the achieved equilibrium. The corporates, businessmen, the sponsors, the property owners, the working community, and the consumers conducting the predicted activity will provide the maximum result. In the vibe of modern complex world, some of the results are certain and predictable. Nyhat, a scholar in 1964, has identified and enlisted 6 concepts in law that have influence in economic development: predictability, procedurability, codification of the goal of legislation that can be seen as one of the codification goals and intention of the country, the balancing factor, and the accommodation. This also enhances our knowledge of how to understand that there are 2 types of quality of law which must be fulfilled for economic system to be functioning in a very smooth way. One is stability and the other is predictability. But between those 2 qualities, we cannot ignore that the justice factors, such as keeping similar treatment with government's behavior pattern standard, which is necessary to keep the market mechanisms and prevent too much bureaucracy. We have to admit that the main weakness in law faced by the businessman in the legal is the legal uncertainty. Legal certainty is indeed necessary to calculate and anticipate the risk for a country. Legal certainty is even one of the most important factors in supporting the endurance of economy in a country. In order to make laws being accommodative to the demands of the economic demands, the government is responsible to make the law with sufficient dignity in responding to any such demand necessary for economic development. Beside this, the legal certainty legal institution must be able to handle the increasing need of efficiency, play its crucial part and role in adjusting the ideas and conditions which constantly develops. With this little note, let me conclude my little thoughts and notes on this topic. Thank you very much, Dr. Sampath and his association, for giving me an opportunity for me to present this. Thank you.
Thank you, Chandrika, for your wonderful presentation. I'm requesting the Honorable Justice Mr. T.N. Vallinayagam to present his presidential address.
மதிய வேளையிலே நல்ல ஒரு விருந்து அருந்திவிட்டு நாம் கூடியிருக்கிறோம். அந்த களைப்பு தீருவதற்காக நாங்கள் சட்டத்தை பற்றி பேச வந்திருக்கிறோம் என்று சொன்னால் அது சற்று மிகையாகத்தான் இருக்கும். என் முன்னாலே இருப்பவர்கள் அனைவருமே சட்டத்தை குறிப்பாக கரைத்து குடித்தவர் என்று சொன்னால் அது மிகையாகாது. வரவேற்பு குழு தலைவராக இருக்கின்ற திரு வீரமணி அவர்கள் சட்டத்தின் பல்வேறு கோணங்களில் இருந்து எலக்ட்ரிசிட்டி போர்டு அவருடைய வழக்கறிஞராக பணிபுரிந்து அதன் பின்னாலே உலக அளவிலே பெரும் வணிக தலைவராக இருக்கின்றார் என்றால் அவருக்கு அடிப்படை சட்டம் உதவியது என்று சொன்னால் அது மிகையல்ல. இன்றைக்கு நமது கதாநாயகர் திரு சம்பத் அவர்கள் சட்டக்கதிர் என்கின்ற ஒரு அழகான தமிழ் சட்ட பத்திரிகையை நடத்தி கொண்டு வருகிறார். அதிலே அவர் தருகின்ற அந்த இன்ஃபர்மேஷன் செய்திகள் அனைத்தும் எப்படித்தான் தமிழில் டிரான்ஸ்லேட் பண்ண முடியும்னு எனக்கு தெரியல. நானும் தமிழ் படிச்சிருக்கேன். ஆனால் அவ்வளோ துல்லியமாக அந்த உச்ச நீதிமன்ற மற்றும் உயர்நீதிமன்ற தீர்ப்புகளை மிக சிறந்த முறையிலே மொழிபெயர்த்து நமக்கு தருகிறார் என்றால் அதை பார்த்த உடனே ஏன் தமிழில் எல்லோரும் வாதாடக்கூடாது என்கின்ற அந்த உணர்வு தூண்டுகிற அளவிலே அந்த பத்திரிகை இன்னும் வெளிவந்து கொண்டிருக்கின்றது. சாரி. அத்தகு சிறந்த மனிதராக இருக்கின்ற சம்பத் அவர்கள் உலகத்தில் இருக்கின்ற எந்த மொழியில் சென்றாலும் அங்கு உள்ள மனிதரை தனது நண்பராக ஆக்கி வருகிறார் என்பதுதான் அவரது அன்புக்கும் பாசத்துக்கும் அவரது மனித நேயத்துக்கும் எடுத்துக்காட்டாக இருக்கு என்று சொன்னால் அது மிக என்று. எனக்கு முன்னாலே காணொலியை பேசிய அந்த சந்திரிகா சுப்பிரமணியம் சொல்லியது போல அவர் ஆஸ்திரேலியாவிலே பேச்சு கொடுக்க வேண்டும் சட்டத்தை பற்றி என்று அழைத்த போது நமது சம்பத் அவர்கள் போகுவதற்கு ரெடியாக இருக்கிறார்கள் என்று சொல்லும்போது உலகின் பல்வேறு மேடைகளிலே அவர் சென்று வருவது மட்டுமல்லாமல் அவர் எல்லா துறையிலும் உள்ளவர்களின் நண்பர்களாக இருக்கின்றார்கள். இங்கு முக்கியமாக குறிப்பிட வேண்டுமானால் எனக்கு பின்னால் பேசியிருக்கின்ற டாக்டர் வனிதா முரளிகுமார் அவர்கள் ஒரு ஆயுர்வேத மருத்துவர். ஆயுஷ் என்கின்ற இந்திய மத்திய நிறுவனத்தில் ஏறத்தாழ 6 வருடங்கள் தொடர்ந்து தலைவராக இருந்தவர். அவருக்கு தெரியாத இந்தியாவில் உள்ள மருத்துவர்களே கிடையாது என்று சொல்லலாம். அது மட்டுமல்ல, சென்னையில் 20 நாள், டெல்லியில் 10 நாள் என்று இன்றும் அவர் பணிபுரிந்து வருகிறார். அப்படிப்பட்ட அனைவரையும் ஒன்று சேர்த்து திரு சம்பத் அவர்கள் நம்முடைய கொண்டு வந்திருக்கிறார் என்றால் அவர் நிச்சயமாக நமது இதயத்தில் என்றும் வாழக்கூடிய நல்ல மனிதர் என்று சொன்னால் அது மிகையன்று. நான் இதையெல்லாம் எது குறிப்பிட்டேன் என்றால் சட்டத்தின் அடிப்படையிலே சட்டத்தை தனது உள்ளத்தில் ஏற்றிக்கொண்டு அவர் உயர்ந்த காரணத்தால் தான் நாம் எல்லோரும் அவரது அன்புக்கு கட்டுப்பட்டு இருந்து கொண்டிருக்கின்றோம். ஆக இன்றைக்கு இந்த லா அண்ட் எக்கனாமிக் டெவலப்மெண்ட் என்கின்ற இந்த செஷனில் குழுமியிருக்கின்ற அனைவருக்கும் முதற்கண் எனது மதிய வணக்கத்தை தெரிவித்துக் கொள்கிறேன். Law is inseparable with life. Naturally, therefore, the Supreme Star Sampath, laudable law lover, started with a Tamil magazine called Sattakadir to inspire Tamilians to understand immortal and exploit law for the benefit of themselves and society. In line with such thought, Mr. Sampath has started Tamil's Economic Conference, and now we are celebrating 8th World Tamil Economic Conference 2021. Naturally, therefore, one of the topic open up for discussion is law and economic development. We have before us so many personalities. I understand Mr. Wilson is not able to come and Ms. Saravanan is on the online. We have R. Meenakshi Sundaram, advocate, High Court Madras, and Mr. Purushottam, advocate, Supreme Court of India. Before I step on to the stage, I had a brief meeting with Miss R. Prem Rajakumari, advocate. She was telling me as to how internationally they are doing legal services, and she is a part of that particular organization dealing with the Delhi Supreme Court and other places. She is also participating. These 6 leaders in law are going to shower on us the purposeful law and the prosperous economic development. Let me, on your behalf and on behalf of 8th World Tamil Conference, invite them and bless them in that field to reach fame and name and serve the society at large and Tamil in particular. We all 7 are bringing to you 7 wonders of law, like 7 Swaras music, as Madras is booming with Isai Vizha or musical conferences at this point of time. Now, please permit me to deal with a few thoughts over the topic. The idea that law is relevant to economic and social development goes back 250 years. Adam Smith stated in his lecture on jurisprudence that the imperfection of the law and uncertainty in its application was a factor that retarded commerce. Max Weber, a philosopher of the late 19th and early 20th century, explained the importance of rational law in economy and society. Friedrich Hayek, a prominent Harvard University economist of the 20th century, studied relevant legal concepts to support liberty as a prerequisite for development. The cause of the failure in the previous law and development movements is that the law reforms projects were developed and implemented without sufficient understanding of the mechanism by which law impact economic and social development, which is affected by various socio-economic factors on the ground. The Law and Development Institute was set up in 2009 to promote studies in law and development and develop a comprehensive analytical model for law and development. And the Law and Development Review was launched in 2008 as only peer-reviewed academic journal devoted to law and development. Recently, efforts have also been made to expand the application of law and development approaches to economic problems in developed countries such as US. Law and development has traditionally been associated with less developed countries in the third world, developing countries, not the economically advanced countries, developed countries. However, the changing economic conditions in recent decades, such as the widening income gaps among individual citizens and regions within developed countries, stagnant economic growth, deepening economic polarization, and institutional incapacity to deal with these issues, render the law and development approaches relevant to the assessment of the economic problems in countries. A related field in new comparative economics, the theme of this research is institutions exert a profound influence on economic development. To understand capitalist institutions, one needs to understand the basic trade-off between the costs of disorder and those of dictatorship. This logic is applied to study the structure of efficient institutions, the consequence of colonial transplantation, and the politics of instant choice. சங்ககாலம் முதற்கொண்டு வணிகத்தில் தமிழர் முனைப்புடன் ஈடுபட்டு வருகின்றனர். திரைகடலோடியும் திரவியம் தேடு என்பது ஒரு முதுமொழி. இருப்பினும் வணிக சமூகம் பல சமயங்களில் நியாயமற்ற முறையில் சுரண்டல் மூலம் செல்வம் ஈட்டி சமூகத்தில் ஏற்றத்தாழ்வுகள் அல்லது சமற்ற போக்கை பேக செய்யும் போது அதனால் பாதிக்கப்பட்டவர்கள் வர்க்க போராட்டத்தில் ஈடுபட்டு வணிகரை எதிர்த்துள்ளார்கள். எடுத்துக்காட்டாக உழவர் சமூகத்தை சேர்ந்த அப்பர் தலைமையில் தமிழ்நாட்டில் பொதுமக்கள் செல்வம் நிறைந்த வணிகருக்கு எதிராக திரண்டு எழுதுவதை குறிப்பிடலாம். தொல்காப்பியத்தில் வணிகருக்கு 5 தொழில்கள் கூறப்பட்டிருக்கின்றன. அவையாவன: தமக்குரிய நூல்களை ஓதுதல், தமக்குரிய யாகங்களை செய்தல், தாம் பெற்ற பொருள்களை நல்வழியில் ஈதல், உழவு செய்வித்தல், பசுக்களை காத்தல் என்பவாம். வணிகர்கள் அரசர்களால் பெரிதும் மதித்து பாராட்டப்பட்டனர். வணிகரை பாதுகாத்தல் ஒரு நாட்டில் இன்ப வாழ்வைக்கு இன்றியமையாது என்பதை சங்க இலக்கியங்கள் கூறியிருக்கின்றன. இமயவரம்பன் நெடுஞ்சேரலாதன் என்னும் சேர மன்னன் வாழ்த்தி குமட்டூர் கடனார் என்ற புலவர் பல வகை உணவு பண்டங்கள் விற்கும் வணிகருடைய குடிகளை காப்பாற்றி வருகின்றார் என்று பொருள்பட கூலம் பகர்னர் குடிபிறந்தாராயி என்று பாடியிருக்கிறார். அரபு நாட்டினர், யவனர், சாவக நாட்டினர் ஆகிய பேர் தமிழ்நாட்டிற்கு வணிகத்திற்காக வரை புரிந்தனர். இதற்காக பல்வேறு துறைமுகங்களும் உருவாக்கப்பட்டன. குமரி துறைமுகம், கொல்லாந்துறை துறைமுகம், எய்த்பட்டின துறைமுகம், அரிக்கமேடு துறைமுகம், காவிரி பூம்பட்டின துறைமுகம், தொண்டி துறைமுகம், மருங்கூர் பட்டின துறைமுகம், முசிறி துறைமுகங்கள், இலங்கையில் பல இடங்களில் இருந்த துறைமுகங்கள் என பல்வேறு இடங்களில் துறைமுகங்கள் இருந்ததை அறிய முடிகிறது. பண்டை தமிழ் சமூகத்தில் காணப்படும் வணிகம் தொடர்பான செய்திகள் வளர்ச்சி பெற்ற நாகரிகம் மிக்க சமூகமாக தமிழ் சமூகம் இயங்குவதை உறுதிப்படுத்துகின்றனர். எனவே சட்டம் பொருளாதார முன்னேற்றத்திற்கு உயிர்காப்பான் தோழலாக பயன்பட வேண்டும் என வாதிட வந்துள்ள வழக்கறிஞர் வல்லுநர்களை உங்கள் முன் கருத்து பெறுமாற அழைக்கின்றேன். வணக்கம்.
நன்றி மாண்புமிகு நீதிபதி அவர்களே. ஏன்னா அந்த டைம் லிமிட்டுக்காக நான் பயந்துகிட்டு இருந்தேன். எல்லாரும் அவங்க நேரத்தை கடைபிடிக்க வேண்டும் என்று திரும்ப கேட்டுக்கொண்டு டாக்டர் மீனாட்சி சுந்தரம் அவர்களை அவருடைய நேரம் 10 நிமிஷத்துக்கு உள்ளாரே முடிக்குமாறு கேட்டுக்கொள்கிறேன்.
Thank you, sir. I will do it within 10 minutes. Good afternoon to everybody, ladies and gentlemen. My endeavor before you is not only to talk about law and development alone, but from the point of individual nation, how these to be implemented. As you have seen, the title of the conference itself is Madras Development on the one hand and World Tamil Conference on the other. These put together, if you see, there is a territorial interest that is lying everywhere. People who live in Chennai or Tamil Nadu, they would like to have the development that is confined to them and to the state. You would have seen a lot of dispute between the state itself in India, where people are fighting and the government itself is being changed. In this scenario, I would like to point out certain apprehension that if the law alone has taken the front line in development of, I don't say it is a country, but industry, whatever way you took it. See, I don't know whether how many of you are aware of this thing. There is one thing that is very important is about the evolution of the East Indian Company, which came to India for doing only business, and later how it changed into a ruler of our nation for so many years. And it took a lot of pain and sacrifice to get independence. As the other day, the speaker, our minister also said, the people of Tamil Nadu who went around the world and suffered and sacrificed to come up to this stage. Then the next step is about the world, that is 2 world war, wherein there is a multilateral treaty that supposed to be came into existence, that's called a General Agreement on Tariff and Trade, where the developed countries are the main participant, and 3 institutions are developed. One is the International Monetary Fund, and the other is World Bank, and the third and the most important is International Trading Organization, WTO, ITO. when these three things were approved for more than 43 countries, and it was sent approved for US alone. See, as far as the application of international treaty and other things, in Indian constitution, there is a provision that we will have to necessarily incorporate into the municipal law. As far as American constitution is concerned, it requires to be approved by the Senate and other forum. Only then the question of making it law will come into play. So when these three institutions went to approval for the American Senate approved World Bank and International Monetary Fund, and they did not agree or approve the creation of the International Trade Organization, that is for the purpose of 53 countries together. So the agreement that is supposed to become a treaty could not happen, become a legal effect, but in de facto it was administered because the other countries mostly followed it. After 36 years, the American economy developed so well, and they found that that product and manufacturers substantially fulfill their market and people, and they want to expand the market. Then they took up this International Trade Organization because already the International Monetary Fund and World Bank were established, and then they took over this International Trade Organization and they moved forward. Doing that, there is a problem of the other countries to convince. So they renamed this International Trade Organization into service also. By that process, they come up with the discussion stating that this is a new type of agreement. It is not tariff alone. It deals with intellectual property rights, service, and other things and all. Believe me, it took more than 8 years for other developing countries to approve it. And at one stage, as Secretary General of the WTO, which is to be constituted, called all the developing nations to say that either you agreed for this proposal or you get out of the organization. That is the only end. So India signed the treaty and became the World Trade Organization, came into effect on 1/1/95. In one of the features, why I am telling this history is the economic development should not be seen as an individualistic one. The law must be regulated. In patent law, there is one provision which is with regard to process patent, how a patent is to be granted for process patent. It is there after two Supreme Court judges gone into the matter, Diction Committee and the Rajagopal Iyengar Committee, which gave a report to the Parliament that the India is required to be follow process patent and not product patent. But in the World International Treaty, wherein we are signed and become a party, this process patent was changed into product patent. The only blessing or the consolation that the developed countries always give to the developing nation is, you want 10 years, take 10 years. You want 15 years, you take 15 years. You want 20 years, 20 years. But you sign the treaty and one day it will become a law. So 1/1/95 we agreed, and 2005 it has come into law. In between, the history is very distinct. That is, when the Congress was in power, they moved the approval. BJP rejected it. When BJP came to power, Congress rejected it. But ultimately, the ultimate end is that is the 2005 midnight. It has been notified through presidential order and it came into effect. So why I am telling you was, when this discussion happened, our people who participated did not approach anything with regard to geographical indication. Whereas the France which participated came up with the proposal of wine and grapes, they got patent. When we objected saying that we got many things, the WTO, that is a developed nation, simply say, all right, go and incorporate in your municipal law and get out. So these are all things happened. I remember, but it is only this thing, 20 years ago when I attended a conference, that is only 11 nations participant represented. In the middle of the meeting, one WTO executive came in and said, why you are discussing about the pros and cons of WTO and all, it is already become a law, you please go ahead with the implementation. There are 11 countries, including our participants, 2 in number, but nobody talked to him, everybody was silent. But only the representative from Brazil said, who are you to interfere? This is an international member country meeting. Do you remember there is a provision in the WTO with regard to review mechanism? That's what we are discussing. That's why we are talking about the pros and cons. This is the status of this, that is the law implementation mechanism. Then comes the other factor is, with all these things, how do you go about it? We are all talking about development. You know, all that is Mukesh Ambani is one of the first and the biggest industrialists. He complained to the government that there is no level playing field in Indian business sector. If he himself claim there is no level playing field, how will you make it level? How do you make it all these things? And America, by this time, that is from 1995 to this date, it's more than 20 years, 25 years, they achieved the target of reaching the developing nations fully. And all the municipal laws of developing nations are changed. Then now they slowly found that we are also developing. As the other people are telling about Mr. Jam Veeramani and Mr. Viswanathan and other people who participated, they slowly became aware and understood the concept of business and the way it is to be approached. We started developing, compete with them. At that time, the American, that is Donald Trump, Trump himself said, there's no point of being a member in the WTO, we want to get out. If it's not useful to us, we'll get out. When you go to World Health Organization, you are now fully aware that they are not informed us about the COVID and all. There's no point in having WTO also. See, these are all the situations that is happening in the worldwide. If you look upon the development that is economic alone and investment, say for example, there are three, I don't want to name it, there are three companies that is running in India, which reached to the state of 4,000 crore loss. But they are running the show. And the fact is the salary is not reduced, the expenditure is not reduced. But how will they match this 4,000 crore loss? Our company, including many of the hotel industry, we had food in President Hotel. He said it will take 4 years for the hotel industry to come back. But what is the role of the government? It is not the law that can reciprocate the economic development or facilitate the comeback. It is for the government to take measures. I know there is a new law which says that in those days, the complaint of the developing country is India, the law is very slow. So the judges, I'm sorry that my judge this thing also is there. So they took it as if it is slow because of them. They try to fasten it. See, in one day, I know one time all WMPs were posted in 21st court, and the only question whether the notice is, sir will know. Notice issued or replied, dismissed, applied, dismissed, dismissed, dismissed. Thousands of cases were disposed of in days. But what is the consequence? The people who waited for years were thrown out of court in a single shot. See, the law on the one hand and the economic development on the other cannot be looked upon equally or simultaneously. That is my apprehension or my approach to the issue. Law, if it is possible, it has to help when the economy is in difficult situation. That is, to my knowledge, I am a practice law and income tax. There are a lot of benefits that is given under the Income Tax Act. To my knowledge, only those industries who are developed or who are in that particular sector alone is benefited. I know there are, I myself is a executive in Institute of Directors wherein my people are here. We are conducting seminars for middle and this small sector and all. But to my knowledge, I am frank that what benefit you can give. See, now hotel industries have gone and the service sector has gone. All these things now I come to understand the robotic sector, if you come into play, even the employees will lose. Now from home work, if you go to Solinganallur side, the entire areas are vacant. How will you reciprocate all these things? Unless all these things are made possible. And one other thing why I am giving the example is when the developing countries compete with the developed countries, developed countries say we will get out. And one other example, when I studied WTO, I always compare it with the European Union concept, wherein one coin, one nation, where they try to adopt one currency. That's what the WTO also trying. As far as the world, the United States and other countries are concerned, European Union is a model code. With that one, they are going to the, now 163 countries are member countries. This is how they are modifying it. See, now if you go to European Union, United Kingdom has gone out. Why they gone out? Because by that European Union concept, all the European countries can move to one country to another. So they all occupied, all people have gone to Europe, United Kingdom for employment. So they said that there is no point, this law is against us. So if you look upon many things where WTO is against you, how will you handle it? Suppose if these countries have gone out, then how will you do the rectification? Is it possible once you go into it? The latest move, one Manad is there, where the time loop is there and all, where can you go back? With all these things only, the country or the government that is running the show, who is the authority for law only, not for development. They can help development, but law is their authority. So the administration must take into account the protectionism that is America now has started. The protectionism play a major role in enacting laws. Otherwise, the laws are happening that is because of the COVID cannot be solved. That is my humble representation before this August body. I thank Dr. V.R. Sambat, who is always give a helping hand and give me an opportunity. But for him, I will not speak in any seminars. I don't like also. Thank you all.
Thank you, Dr. Meenakshi Sundaram. Meenakshi Sundaram is our one of the member of our organizing team. It's always helpful to conduct this conference in grand manner. Now I am requesting Ms. Prem Rajakumari. She is an upcoming lawyer, especially practicing in corporate law, income tax law, and civil law. She studied in School for Excellence as well as Jindal Law School at New Delhi. Apart from that, she got a gold medal in, I think, in PG course. She served in Government of India Ministry of External Affairs for some expert committee member. I'm requesting her to present her speech within time limit for 10 minutes.
Thank you for the warm invite, Dr. V.R. Sampath. Honorable Justice Valinayagam, dignitaries on and off the dais, a warm good afternoon. It's indeed quite a tough task to be a speaker in the session immediately following lunch, but I hope to keep it brief as possible. So the topic that I've chosen for presentation today is competition law and issues in cross-border transactions or extraterritoriality. In the current economic environment, globalization has paved way for international trade. Mergers and acquisitions play a vital role in the transnational business scenario. With the rise in M&A deals globally, issues relating to anti-competitive practices also arise. Now, this violation of anti-competitive practices is in terms of abuse of dominance, formation of cartels, combinations, etc. So the standard of laws of a particular nation govern the laws of that particular state. Whereas when there are undertakings such as Apple or Samsung or General Motors, they have their products throughout the globe. So their products are sold globally, as a result of which nations frame their own laws to combat anti-competitive practices. Now, coming to the aspect of global presence of companies, the violation or anti-competitive practices of companies need to be checked upon by the laws of that particular state. Now, this has led to a practice where nations need to cooperate with each other to frame laws to combat the anti-competitive behavior of that particular firm in that particular state. Now, put it simply, any state would frame laws to protect the interest or well-being of its own citizens and its own people. On the other hand, anti-competitive practices of companies or firms need to be checked upon by the company, or by the state in its own jurisdiction. And the main issue is with respect to the jurisdictional aspect of the firms. On a practical note, states do not always cooperate with each other and lead to investigations. The statutory provisions of particular states need to be looked upon on the issue of extraterritoriality. Now, with respect to the context of extraterritoriality of competition law, the much needed R or the much needed requisite of the R is to protect the interests of the local people as well as the corporates in terms of combating the anti-competitive behavior of firms in that particular jurisdiction. Now, in the famous Alcoa case, the concept of extraterritoriality was first discussed. The appellate court held that the concept of extraterritoriality can be exercised upon by a state when it has an impact on that particular state. The jurisdiction of a state can be exercised upon firms which have their presence outside the state but has an impact or a consequence in the particular state. Now, this issue of extraterritoriality by a state needs to be looked into not only by that particular state, but also in a global scale, so that the extraterritoriality can be checked upon and the violation with respect to anti-competitive practices can be combated. Now, one of the important aspects that needs to be looked upon to combat such practices by companies is for states to enter into bilateral or multilateral agreements with one another. Now, another important aspect that needs to be studied is with respect to the binding nature of these agreements. Though these agreements are entered into between states, the binding of these agreements are not enforceable. Hence, another issue which needs to be looked upon in these aspects of entering into agreements is to have an international regime for combating these practices. Now, the WTO, as you all know, has a global presence and is an active body in protecting the trade policy or promoting international trade as such. So an international body similar to WTO is required in the aspect of competition law to solve this aspect of concurrent jurisdiction and cross-border mechanisms or cross-border transactions in combating this anti-competitive behavior of firms worldwide. Thank you.
Thank you, Prem Rajakumari. You completed within 10 minutes time limit. And now I am inviting Dr. A.N. Purushottam. He is one of our organizing committee member and also strongly and a long time associated with our activities. He is practicing in Madras High Court, Andhra Pradesh High Court, Telangana High Court, as well as Supreme Court. Even though it's not getting a proper position in Chennai, always we are giving always top position in our Madras Development Society and World Tamil Economic Foundation. I'm very happy to invite Dr. A.N. Purushottam to present his speech within time limit of 10 minutes.
Good afternoon to everyone, all present here in the dais and off the dais. I thank especially our Dr. V.R.S. Sampath and our Dr. Valli Nayakam, Honorable former Judge of Karnataka High Court, and Dr. Meenakshi Sundaram. He is the professor while I am studying in ML. And I thank especially our A. Tyagarajan, Dr. A. Tyagarajan, and Senior Advocate V.R.S. sir. I thank Veeramani sir. He has given this opportunity as a chairman of this 8th World Tamil Economic Conference. I thank one and all. My sincere appreciation for all these distinguished speakers also. Dr. Prem Rajakumari also, thank you. As time is the essence of evening, I would like to jump straight on today's topic, the mutual interrelationship of law and economic in development countries of all our world. Before heading into the subject of the topic, I would like to present my short insight on the recent and very recent, you can see in the newspapers also, 2 days or 3 days ago, there was a headline in the news that a court in Moscow had fined Google $98 million for repeated failure to delete content that was deemed illegal in Russia. In Indian rupees, that amount equals to around 700 crores. That fine imposed by the Moscow court was calculated based on the Google's turnover this year in Russia, which is approximately about 8% total revenue generated by the US company. So when a company internationally not followed the law, economic will go down. So by this not following these acts, these laws, the Google company has economically, they have suffered, and what all the economy they have gained, they have lost. Not only Google, but earlier this week, social media companies like Facebook, Twitter were also fined for not adhering to the rule imposed by the Russian government. These laws came into effect on December 2020 last year, where the Russian members of parliament in the lower house together passed 2 bills that restricts access to the US serial media companies that are found to criticize the Russian government and media, and also to impose big fines on platforms that do not declare such banned content. The first bill introduced by lawmakers would allow Russia to restrict access to fully blocked websites by Twitter, Facebook, and YouTube. The second bill would be allow Russia to fine internet providers and size between 10% and 20% of the previous year Russian-based turnover for repeatedly failing to remove banned content. By introducing such laws in their country, Russia saw a steady increase in the usage of Russian-based social media startup platforms and a gradual decline in the usage of US-based social media platforms. That's why if any company, international companies or Indian companies who have not followed the law, their economy will fall down. Whatever they earned legally, that amount will become illegal. So any amount that we earned, that must be followed by laws of international and lands of the law. This eventually led to an economic shift in their country, where more and more local established social media websites and content flourished throughout the year, generating revenue and become economically efficient in this sector. Economics generally provides a behavioral theory to predict how the people of that country respond to laws. These bills introduced by the Russian government held a positive response from Russian citizens. The response of people is always relevant to making, revising, repealing, and interpreting laws. On a similar instance, in India, the Department of Telecommunication has imposed a penalty of rupees 2,000 crores on Vodafone company and rupees 1,050 crores on Airtel company for their refusal to allow interconnection for the Indian-based telecom company Jio services in the year 2016, which had affected over 75% of the quality of services for the company. We all know how the introduction and impact of Jio services lead to an economic shift in the Indian market with the cheapest internet access to the users. Therefore, the Department of Telecommunication has given Vodafone and Airtel companies 3 weeks to pay that fine. As you see, law and economic development today reflects a similar division. Economics has changed the nature of legal work, the common understanding of legal rules and institutions, and even the practice of law. American Nobel winner Douglas North famously summed that law and economics relationship with an example, a legal system that does not penalize thieves or protect honest people from fraud and other forms of aggression would not offer the right kind of environment for economic growth. And in all, I conclude our thought process of law of development would demonstrate our motto to periodically and calculate through stable, transparent, legal region with regulated economic development to our nation, advantages and usage of our knowledge in public domain and with the use of traditional knowledge. Our Prime Minister has taken a measure to convert manual transmission of digital transportation where cyber security is going to play a major role in India and assess the world platform policies and procedures, standard legal procedures to be examined by GOs in personal data protection bill as per approval in the year 2018 with Justice Sai Krishna Committee. I would like to conclude my speech today by suggesting that future of law economics lies in this form of mutual relationship. It lies not in making law subsidiary to economics, but in using the analytical strength of economy in conjunction with empirical insights into people's wishes that legal system gives. So the combination of both theory and practices will enhance to serve our wants and needs of future. I did like to take this opportunity, thank Dr. V.R. Sampath providing me this platform. His able guide has always encouraged us. I thank him for his interest, his hospitality and confinement support to the betterment of law, justice through his publications like Sattakedir and other publications. I once again thank all the distinguished guests and all the present the delegates here. Thank you.
Thank you, Dr. Purushottam. You've given a very hot topic today about the corporate companies, how it is facing problem violating the law. Thank you, sir, everyone. Now I'm requesting the Honorable Justice Bhaskaran to honor the guests of the speakers today. Sir, first time Honorable Justice T. N. Vallinayagam, Chair of the session, will honor. Next time requesting Dr. Meenakshi Sundaram. Next வந்து யாரு பிரேம் ராஜகுமார். அடுத்தது புருஷோத்தம். எல்லாம் சேர்ந்து